Welcome to the Australian Government Legal Network Seminar. As you know, this is the second part in a series of three that is sponsored by the Office of Parliamentary Counsel. Today's seminar is on managing a legislative project. My name is Tony Walsh. I'm one of our Senior Assistant Parliamentary Counsel with the Office of Parliamentary Counsel. That's not actually why I'm here today, though. I'm here as facilitator from the AGLN for the seminar. I'd like to thank you all for coming. You're probably wondering where Libby Carroll is. Libby's taken on the role as chair of the board of AGLN. And so Joe Rule and I will be sponsoring the Professional Development Committee for the AGLN for the next little while. As many of you know, AGLN is largely a volunteer network of lawyers who together try to help to improve understanding and conditions of expertise within the legal profession in the Commonwealth. And I just wanted to say a thank you to the Professional Development Committee. Before I took on the role of a sponsor, I don't think I was ever really aware of how much work is involved in putting together a seminar series for the AGLN. And they do a fantastic job, largely on a volunteer basis. So I just thought I'd put in a plug for them. So today's seminar will be in a very similar format to the last one. I'll introduce Peter Quiggin in a moment, who many of you probably know already. We will have three speakers, each of whom will speak for 20 minutes, and then at the end of the seminar we will set aside some time for questions from the floor. So I'll now pass to Peter Quiggin, First Parliamentary Counsel with the Office of Parliamentary Counsel.
Thanks, Tony, and welcome to everyone here today. Today's one, as was mentioned, is managing legislative projects, and it's being done sort of looking through the sort of spectrum of the offshore petroleum and greenhouse gas legislation. And so we've got three speakers who have a connection with that legislation, and I'll introduce all three of them now and then get them to speak in turn. So the first speaker will be Jessica Round. She's the manager of the strategic policy area in the offshore resources branch and in the resources division of the Department of Industry, Innovation and Science. And she's got primary responsibility for the management and development of legislative and regulation amendments to the Offshore Petroleum and Greenhouse Gas Storage Act 2006 and the various associated acts and regulations. And they provide the national regulatory regime for the exploration and production of offshore oil and gas, which is obviously a key area for Australia. Jessica's been involved in a number of significant regulatory reforms and projects in recent years, including the Single National Regulator Reform Package, implementing the government's response to the Montara Commission of Inquiry, and those projects included the development and introduction of two compliance measure themed bills to Parliament and the consolidation of the regulations. So Jessica has a long experience in various positions within the Department of Industry and its various predecessors in developing and delivering programs. She's also worked on projects such as the Regulation Reform Task Force Secretariat at the Productivity Commission within the Department of Finance. And after Jessica, we'll have Amanda, who's currently the Senior Legal Counsel but has also worked as the Legislation Liaison Officer, which is obviously one of the key positions in legislation projects at the Department of Industry, Innovation and Science. And prior to joining the department, Amanda spent 5 years in private practice as a litigator. As the Legislation Liaison Officer, Amanda managed a busy and demanding legislation program for the department, both overseeing the passage of primary legislation and the implementation of subordinate legislation. She's worked on a variety of significant and challenging legislative projects, and these have included developing the Northern Australia Infrastructure Facility Bill, numerous offshore petroleum and greenhouse gas storage amendment bills, and implementing an amendment to the Industry Research and Development Act that created an innovative mechanism for establishing legislative authority for the department's program expenditure. More recently, Amanda's managed the legislation process for the Space Activities, Launches and Returns Bill, which I think is featured on the front page of the Canberra Times today, which was introduced into Parliament this week. So we all know where the launches will take off from. Some of us are a bit worried about where the returns might happen. Our third speaker will be Nick Horn, who's from OPC, and Nick tells me he first learned of legislative drafting, or of legislative drafters, when he instructed them while working for the ACT and External Territories Administration, which is similar to me. I'd never heard of drafters until I worked at the tax office for a while. He used to instruct, and one day we met these strange people. Then from so he was there from 1983 to 87, and then he turned himself into what he described as one of these strange creatures, drafting legislation for the ACT administration, and then that turned into obviously the ACT government. Nick also did a secondment to Ontario in 2002, and in 2005 we managed to poach him from the ACT and get him to come and work with us at the Commonwealth Office of Parliamentary Counsel. And he's been a senior drafter at OPC since 2008. In his spare time, he's taught a drafting course at ANU for a dozen or so years, has conducted drafting training courses in the Pacific, and like all drafters, he has a variety of experience across a wide range of subject matters. For example, regulatory laws like the offshore petroleum and greenhouse gas regime, the theme for today, criminal law, including the Criminal Code and the Crimes Act, commercial law such as Corporations Law and Personal Properties and Securities Act, and also social welfare legislation. So they'll each speak in turn. So I'd ask you to welcome Jessica.
Hi. As Peter said, I manage the strategic policy section in Offshore Resources branch. It used to be called legislation review because essentially the main responsibility for my team is to look after the implementation of policy decisions to the Offshore Petroleum Greenhouse Gas Storage Act and related acts and the regulations that sit underneath it. But we obviously work very closely with our central legal area through the LLO to implement such changes together with OPC. I thought it might be beneficial to give a bit of an overview. I wouldn't want to pass up an opportunity to spread the good word of the upstream petroleum sector and the legislation that overlays it, because it's actually quite complex piece of legislation. It's 3 volumes, so it's nothing like the Tax Act, but it actually sets up quite a complex legal and regulatory framework for looking after the sector. So the upstream petroleum sector includes all exploration and extraction activities, so it's up until the point that the product is actually shipped. So everything that takes place from exploring for the resource through to drilling and extracting what we call production of the resource, and then it's loaded onto ships and taken away. We look after upstream petroleum, so that's essentially oil and gas. There is a separate piece of legislation which is for offshore minerals as well, but we're not talking about that today. We're talking just about upstream petroleum activities. These activities occur onshore and offshore. All of the onshore activities are looked after by the states and Northern Territory in their own jurisdictions. And then the responsibility from the Commonwealth's point of view, and this is set up under the Constitution and the Offshore Constitutional Settlement, which I won't go into a huge amount of detail on, but was an agreement, the intergovernmental agreement that was put into place some time ago to establish those offshore areas for between the Commonwealth and the states and Northern Territory. So the responsibility for Australia's Commonwealth offshore areas starts at the 3 nautical mile mark as you move offshore, and goes right out to the edge of the Australian jurisdiction. So they're quite large areas, and they're split into. There's an offshore area that exists off, say, Victoria, New South Wales, Queensland, so each of the states in the Northern Territory. There are also offshore areas that are around our external territories as well. And we also do, which again, it's not under domestic legislation, well, it is mentioned. We also do have offshore activities that occur jointly between Australia and East Timor as well, which you may or may not have seen in the Canberra Times and other national press recently, international press recently. because there has been some discussions going on between Australia and East Timor about the coastal water boundaries that exist between the two countries. Just to give you a high-level understanding of how the framework is set up, because otherwise I'll talk about the bills and it really won't make much sense. We're going to talk about a couple of bills today that were progressed back in 2015 and 2016, which were very specific policy measures to do with the framework, but without explaining the framework itself, they won't make a lot of sense. So the OPGGSA sets up the legal and regulatory framework for administering those offshore areas that I spoke about. It's not just the Australian government that's involved as a decision maker. We actually have joint decisions that occur with each of the state and Northern Territory governments in their offshore areas. They're specifically resource management decisions that occur at that vanilla government level, as in the political level. And that's to do with the granting of, releasing of acreage areas for then companies bid on those areas. Then they're granted titles. And then there are other core decisions that take place with relation to resource management and resource security issues. So there's a joint authority, a statutory authority that's set up for each of the offshore areas, as well as the external territories and Eastern Greater Sunrise, which is part of the Timor piece of the puzzle. And the joint authorities constitute my minister, the Resources Minister, the Commonwealth Resources Minister, together with his counterpart in each state or the Northern Territory. We also have set up under the legislation two other Australian government bodies. There's the National Offshore Petroleum Titles Administrator, NOPTA, and the National Offshore Petroleum Safety and Environmental Management Authority, which is our regulator, NOPSEMA. So they perform technical advice and regulatory functions under the OPGGSA and related acts and regulations. Peter made reference to a project that I worked on a few years ago, which was the establishment of the single national regulator. And it was essentially around that time that NOPTA and NOPSEMA were established. I won't go into the history that existed before then, but there really was a greater involvement of the states and Northern Territories in the regulatory activities prior to that time. The OPGGSA has gone through various iterations over the years. The original legislation was actually drafted and put into place in 1967, but it has gone through some fairly serious revisions since then. There was a modern rewrite that occurred in 2006. 2008 greenhouse gas storage activities were incorporated into the Act. This was under the previous government's carbon pricing push. Then there was, single national regulator reform. We had the Montara incident that happened and there was a commission of inquiry. So, look, I guess the point that I really wanted to make, it's quite a complex, long piece of legislation and regulations with many different policy components in there. And we've got interactions with our state and Northern Territory counterparts as part of those policy and regulatory processes. So hopefully that sets a bit of a scene in terms of the policy area and the legislation. So next I thought I would talk about, for those who perhaps don't work on legislation yet, although I'm sure you aspire to, policy matters that impact on legislation can come from many different sources. And just to name the key policy origins, and really what the point of listing these is that it actually influences how then you go about the policy process and the implementation process as well in terms of gaining your additional authority, and also how you go about consulting on the policy and legislation necessarily as well. So there can be broad government or ministerial announcements that are made about policy measures. Election commitments are made, so depending on which side is elected, you then obviously looked at all the documentation that was put out in the public sphere as promises in the campaign, and those matters, I don't want to tread on the toes of Amanda and Nick, but those matters with the immediately following legislative period are essentially given top priority. It actually becomes very difficult to, if you've got other policy matters that you've been working on in the background and hoping to get introduced, it can be quite difficult to get it introduced in that legislative period that follows an election. There can be other portfolio legislation changes that are being made that necessarily have consequential amendments for your legislation. For example, cabinet decisions or just other whole of government policy changes. There can be developments in law, such as court or tribunal decisions that are made, which either you realise have a direct impact on the way that you thought your legislation worked, and you realise because of the decision there might be a loophole. It's not quite meeting the policy objective that you were setting out to deliver there. So it's a reason to dip back into your own law, your legislation, and fix that, so that to set it back on the policy track that it was intended to travel on. There can also be other decisions made in courts, any type of court up to the High Court, where you realise because the decisions about, well, for my sector, it's the resources sector, or they might be administrative law developments as well, and you realise that there is an impact on either your policy or your legislation, and so you seek to address and deal with those issues that have arisen. There can also be the COAG or other ministerial council decisions, so that's an example where there's a decision, kind of like election commitments, I suppose, made at quite a high level and possibly in isolation away from your own policy area. However, it's a decision that's been made by a higher authority, and then you are tasked as the detailed policy area with going about and working out how that's best implemented. There are also whole of government reviews, such as those conducted by the Productivity Commission. There was a Productivity Commission Better Regulation Task Force that I actually was involved in the Secretariat work for a number of years ago. They had chapters on all parts of Commonwealth legislation, recommending changes that could be made to improve those areas of legislation and regulation. And ironically, I ended up in one of those areas that was tasked with implementing, not the chapter that I'd actually worked on, thankfully, but implementing the recommendations of that task force. And it actually ended up with the creation of the single national regulator, which, objectively speaking, is a good thing, rather than having 7 different regulators making inconsistent decisions across the country. A very common policy source for us is, so we have a good ongoing relationship with our regulatory bodies, and they'll bring issues to our attention because they're working at the coalface, so to speak. They can tell us where things are not quite working as they were intended from a policy point of view. Or they have identified issues that they have with pursuing compliance and enforcement, so that that provides a policy impetus for us to go in and look at what needs to, how we can strengthen and improve those aspects of the regime. Of course, as well, the branch that I work in has many policy areas that are oversighting the various components that sets up the regime. And policy reviews are ongoing. I always include in our second reading speech that our regime is subject to continuous improvement. We're always looking to ensure that it is best practice and keeping in line with like international comparative. I mean, it's very much an international industry anyway. Keeping pace with comparative regimes out there like the US, Canada, UK and Norway are our key regimes that we try to make sure that we keep in fairly good alignment with. There's also other policy reviews that are spurred by not extraneous events, but they're not determined by us, and that is an example of that is sunsetting arrangements with a 10-year, in theory, a policy review would occur every 10 years. I would say it's true to say for the offshore regime, we conduct policy reviews quite continuously, so it's not as if we wait 10 years before we conduct a review of our regulations. Also matters that are raised by industry, so the policy areas in particular meet with industry participants and conduct consultation sessions with them to really just ensure that policy from the government and also industry's point of view, and obviously industry has their own particular vested interests in how things might be run, but sometimes there are good matters that are raised by our industry stakeholders, and we respond to those accordingly. One of the bills, well, both of the bills really, the second bill, really relates to a matter that was pushed by industry. It was something that they felt needed to be addressed in the legislation for a particular agreement to go forward, so we responded along those lines. Oh, and the last policy origin that I could think of, I might have missed something in that list, but it's an inexplicable and unplanned event, and that's actually the first bill that I'll be talking about, where it was brought to our attention that Geoscience Australia was going around the country remapping the coastal water boundary using updated technologies, and I'll go into more detail about it, but that actually exposed a gap in our regime, and we had to respond quite quickly to that because there were quite often projects that straddle the boundary, and with the boundary moving, we had to make sure that, I guess from a holistic point of view, that those projects weren't put into jeopardy. So there's two bills that we thought would be useful to kind of talk about around various elements of the legislative project process, because, well, I've worked on them, Amanda's worked on them, and Nick has been our drafter for many of our bills, not these ones in particular, I don't think, but he's still familiar with the developments. The first bill, unfortunately, a lot of our legislative bills are named this, so it can be quite confusing, but it was the Offshore Petroleum Greenhouse Gas Storage Amendment Miscellaneous Matters Bill 2015, and it did contain miscellaneous matters, but it also contained a very important policy measure, which is the one I'm going to talk about now. So it probably should have been named something that was pointed more towards the significant policy measure in it. And it was where the coastal water boundaries, and this process is still actually going on. To go back to first principles, I suppose, geography is very important in terms of like issuing the titles and also the way that companies go about exploring. The offshore area is divided up into what we call blocks that go along, the longitudinal and latitudinal lines. But also the titles themselves are constrained, especially around the coastal water boundary, which is the 3 nautical mile mark. So there might be a title that goes right up to and sits against the edge of it. And there could also be a title that sits on the other side that similarly sits up on the edge of it. So what caused the remapping exercise has nothing to do with the resources industry. There was some alleged illegal fishing that was going on up in the northern waters of Australia, so completely unrelated to oil and gas. However, in trying to resolve that issue and whether it was illegal fishing or not, Geoscience Australia decided to, using much more high-tech, I don't even know the last time that they mapped the coast, well before my time, that they did the mapping exercise. But technology obviously is one of those things that develops quite rapidly. And using, satellite imaging and all this sort of stuff, they could actually like zoom down and see all these sorts of like rocky outcrops, and just more accurately map the mainland as well to set that 3 nautical mile mark. The first jurisdiction that they did this exercise in was off Western Australia, and Western Australia is where far and away the majority of offshore resources activities takes place. It's about 70%. And they found a very significant impact that went through. It's called the Browse Joint Venture project, and it already did straddle the coastal water boundary. But then the boundary change within that was quite radical. They identified these reefs that sat above the water for the requisite period of time, and some rocky outcrops. So the change, and we have a split when there's a project that straddles the boundary. You have to work out an apportionment agreement, because the revenue, in terms of the taxation revenue and also royalties, are split between the Commonwealth and the state. WA's royalty increase, or their interest stake in that project, grew from 5 to 65% overnight, essentially. But more importantly, the boundary change was quite radical. And a gap was identified in both pieces of legislation where no one had ever envisaged that this was going to happen, and there was no mechanisms of like automatically or even granting new titles. If you can it'd be good at this point in time to have a whiteboard or draw. But essentially, I mean, the way that the boundary was moving, without granting a title over that area, it was going to create what we call vacant acreage, because there's no title over the area, and it would essentially have meant that the company lost its rights over what is a very significant resource. So we worked quite closely with the Western Australian government on this, because both of our pieces of legislation essentially needed the same set of changes made to them to allow for automatic grant of title on both sides, so that the companies didn't lose their resource that they've been exploring over and developing. Well, they haven't gone to the development phase yet, but they've put a significant amount of money into exploring and holding these titles over time. So around this time that the coastal water boundary change happened, that what was also happening, which was related to it but separate, was the negotiation of an apportionment agreement. So, and that's for the split of revenue, basically. It's agreeing that 60%'s on WA side, 40%'s on Commonwealth side, and that's how you split PRT and other royalties. And this bleeds into the second bill that I was going to mention. I'm running out of time already, but in negotiating the apportionment agreement, it was one of those interesting exercises where I guess different parties it was a tripartite agreement between the Commonwealth, WA and the companies involved. And the companies we went through a significant drafting of the agreement exercise and negotiations about the exact split. But there were actually some prerequisites or preconditions that were built into that agreement. So for it to commence, the companies were requiring the Commonwealth and Western Australia to implement changes to their legislation to deal with not just the boundary change, but also other aspects that were contained in the legislation where you thought it was a single petroleum pool, because an apportionment agreement is essentially supposed to be about one field, one pool. But then as your knowledge of the geology increases, you discover, well, it's actually maybe 2 or 3 pools, or, bits and pieces here and there. It's not as interconnected as you first thought it was. So that was another key piece, policy measure that was included in the second bill, which was the Petroleum pools and other measures bill. And that actually had and Amanda will talk about this, but it had a retrospectivity component built into it, which raised the attention of some parliamentary committees, as retrospective application often does. I was going to go into more detail about those bills, but I am running out of time. I guess in identifying key issues from a policy point of view on things that could affect the delivery of your legislative project. Firstly, policy development and approval is a key aspect that you have to manage quite carefully. The approach that you take to, and even the number of policy approvals that you might have to end up getting, and also the timing of that, I feel is quite related to the policy origins that I was talking about before. Because sometimes there can be, if it comes from a cabinet decision, you've already got that overarching policy authority, and then you might only have to get, one or two mop-up letters done to deal with the implementation aspects. But if you're starting from scratch, then in that you're doing a policy review internally, you can control, I suppose, gaining the policy authority more. What I would always recommend, though, is you consider as early as possible the right type of policy authority that you need, because, of course, with major measures that impact on a number of portfolios, you need cabinet agreement. Whereas with our policy authorities, where we're dealing just with the OPGGSA, you're dealing with one piece of legislation more often than not, but it's not always true that this is the case. You can just go to the Prime Minister and get that singular approval rather than cabinet approval. We have found on occasion, we've got levies in our Act as well, because we've got everything in there, levies that fund the regulator. So if we're tinkering with the levy arrangements, we might have to go to the Treasurer or the Finance Minister as well as the Prime Minister. I guess what I'd recommend is think about policy authority early, talk to PM&C, talk to your LLO, talk to PM&C as well about what their expectations might be, so that you're not left at the last minute scrambling for policy authority and trying to get it, prior to introduction. Consultation is the next key thing from a policy point of view, and this can actually eat up a lot of time in your legislative project. As you go through an iterative drafting process, and you might want to consult on an exposure draft with your key stakeholders, and of course if you want to do that, you need to get the Prime Minister's approval to do that if it's outside of government. I feel from a policy point of view, it's you're best to go as early as possible to your stakeholders, get them familiar with the policy, even just at a higher, broad level, so that then when they're hit with an exposure draft, which can often be quite detailed, and coming at that cold would, it's very difficult to deal with. So if you drip feed information, I have even on occasion, I don't make a practice of it, but sometimes I'll even share in confidence drafting instructions with our regulator, not outside of government, so that they can familiarise themselves with the changes that are being proposed, and they can understand the policy drivers that are sitting behind that. It gets them on board sooner, I think, if you can bring them along the journey, so to speak. Another key element, but the other two might talk about this as well, is quite often you need to get legal advice, including constitutional advice on your legislation. We quite often, because of the nature of the regime and dealing with the states and territories and its location, we quite often do have to get constitutional legal advice. We're quite lucky in our branch. We have an outposted AGS lawyer who sits with us 3 days a week around the whole year. So quite often she can identify early on that we will need some constitutional legal advice, but sometimes it is also unfortunately the case that it's only through the last drafts that you're doing that then the drafter might bring to your attention that you for him to put it forward, or her to put it forward, we'd need to seek constitutional advice. The final, and I guess in dealing with all of these things from a policy point of view and process, and you would do this with any project as best practice, mapping out your project early on to ensure that you build in milestones, especially critical ones that exist towards the end, and Amanda will talk about those. Make sure that you build in sufficient time to turn around those, what is quite often an iterative drafting process, and consultation phases and obtaining your approval. I've already touched on it briefly, but policy authority, the ideal and what happens in practice. So the ideal is a very planned, staged and controlled approach, very measured and well thought through. Unfortunately, in reality, that just doesn't always happen. You're given a policy directive from on high and you need to sort out the details and how it's going to be implemented. So then it becomes quite a reactive and evolutionary policy process that can, especially for us, quite often happens through the drafting process and our consultation process. So I guess the best advice I would have is be flexible. Like, think about it as early as you can, but you do need to be quite flexible in getting that policy authority. Another element that was mentioned for the seminar is how to write a good policy letter. I view this as being synonymous or the same thing as how to write good drafting instructions or how to write a good EM, because all three of those things needs to clearly explain what your policy is, so what the intent is, especially in terms of the EM, so that when people are looking at legislation later on and trying to interpret it and what it really means, if you can be as clear as possible as what the policy intent is there, it leaves less room for misinterpretation. I mean, at the end of the day, a court is going to interpret the words that is actually in the legislation, but you never know, they might seriously consider the explanatory memoranda that you have attached with the bill to do that. So we always spend a lot of time right from the outset in the project writing our EM as we are drafting. We don't leave it till the draft's settled and then we write our EM. And this is the approach that we take, and not everybody would take it, but I would recommend it because you will find yourself in quite an awkward and crunched situation if you left it till you had your draft settled. Obviously, we feed our EMs through the LLO, as well as drafting instructions, and our policy letters. We even give them a look at that as well. Actually, the drafter always looks at the policy letters as well. We seek guidance from him or her to ensure that we have full coverage of what's contained in the bill and to make sure that we have full policy authority, so there are no questions asked when it comes to introduction. I think I've kind of run out of time, and I probably have. I was going to talk a bit more about consultation, but I can maybe jump in later or answer questions about it.
All right. My role today, I guess, is to talk about managing a legislative process from the perspective of a legislation liaison officer. And I had a very wise mentor once describe the legislative process and the role of a legislative liaison officer as the dark arts. I'm not sure that the reality is quite that sinister, but it's definitely true that in a legislative process there are a lot of intersecting processes, areas of expertise that all need to come together collaboratively in order to produce a successful outcome. So as the LLO, I work very closely with my policy counterparts, with the Office of Parliamentary Counsel, often with Department of Prime Minister and Cabinet, and the Minister's Office, to ensure that what we produce satisfies everyone's needs. There are so many aspects of a legislative process that I could, A, probably bore you to tears in minutes, but B, definitely waffle on non-stop to the end of the day. Instead, I'm going to try really hard to keep to a strict 20-minute limit and just identify some of the more pertinent themes and processes from my perspective. I've also brought along a little prop, the Legislation Handbook. This is a fantastic resource for the more detailed step-by-step guide to the legislative process. But for today, I've limited my talk to just 4 key points. I will address issues that can affect the delivery of a legislative process, managing ministerial expectations and competing parliamentary government priorities, parliamentary committees, and in particular the Senate Scrutiny of Bills Committee. And finally, I'll talk about the continuing role of a department after the introduction of a bill. I will at times link back to one of the bills that was identified by Jess, the Offshore Petroleum and Greenhouse Gas Storage Amendment, Petroleum Pools and Other Measures Bill of 2016. But from here on in, I'm just calling it the Petroleum Pools Bill. So my first point, identifying issues that can affect the delivery of a legislative project. From the perspective of an LLO, generally one of the first inputs we have to a legislative process occurs after policy work has already started and significant work has been undertaken. We get involved when legislative bids are due. Submitting a bid to the Parliamentary Business Committee, or PBC, for consideration to be included in the next sitting period is quite a process and often takes longer than you would expect. So working backwards, bids for a sitting period are considered at the last PBC meeting in the sitting period before. So if we are looking to introduce or have a bid for the spring sittings, those bids would be considered at the end of the winter sittings. This often means that bids have to be submitted well in advance of the sitting period in which you're planning to do that work. And so for spring program, you would be submitting your bids to the LLO and then up through the Minister's office, generally in the middle of the winter sittings. Submissions of bids have strict deadlines, which often creep up faster than expected. And the department has a process that must be followed. We prepare the briefs, we prepare the bids, and then at a departmental level, we recommend an order to the Minister of priority within our own department. The Minister then considers that and agrees, signs a letter to the Prime Minister with the recommended bids in order for the Department of PM&C to compile and collate a whole of government program of bids, so taking our bids, looking at them in the context of all of the other bids that have been submitted by departments, and preparing a whole program for PBC to consider and approve. There are different bids categories that can be used, and they have different timing requirements and expectations. The first and most critical bid is T category. It took me far too long to realise that T stood for time critical. But these are your most important bids, and the general expectation is that they are introduced within the first 2 weeks of a sitting period and passed by the end of that sitting period. We've then got A, which is your high priority bids. The intention is that you'll draft and introduce in one sitting for it to be passed in the next. A relatively new category that seems to be emerging, probably due to the volume of bids that are being submitted, is A for drafting only. I feel that's fairly self-evident. B notionally means that you have a medium priority bid, but in practice and with current resourcing, I've found that it means you might get lucky to be appointed a drafter. Finally, we've got C category. Again, notionally, this means that it's a lower priority bid, but in practice, it means you have almost no hope of being appointed a drafter. These are becoming extremely rare to see on a program, and I query whether you would submit them in the first place. So once you've got your bids in, they go to PBC for consideration. It has become increasingly important in recent years that any legislative proposal you're putting forward is adequately justified. You need to justify not only the category that you're bidding for and the urgency or importance of your bid, but PBC also considers these in the broader context of government priorities. So your greatest chance of success is if you can link your bid to one of the broader government priorities that you know are being progressed. Using Petroleum Pools Bill as an example, we submitted a Status A bid in autumn 2016. At that point, it was part of a larger Miscellaneous Measures Amendment Bill, which unfortunately did not get up in that sitting period. So for the next sitting period, winter 2016, we varied our bid to be a T status, so time critical. We had to include specific extracts as to why the passage of this bill could not be delayed. Just briefly outlined why we had why this bill was so important, and we had to identify that in our content that went to PBC so that they could clearly understand why it was a priority, not just for the department but for government as a whole. We obtained the T status we needed, introduced in September 2016, but as is the way with legislative projects, they did not quite go to plan. It passed within the time that we needed, but took a little longer than expected, and it wasn't until February 2017 that we got our royal assent. So, rattling off the list, it was introduced in the House of Reps in September. It was introduced in the Senate in November. It then passed both houses on the 8th of February and was assented to on the 22nd of February. That sounds like a relatively straightforward process, but there were a lot of intervening steps and challenges along the way, which I'll expand on as I continue today's discussion. I have here to briefly mention drafting resources. I'll probably leave that for Nick to delve into more detail, but my key pointers would be that generally you will not be allocated a drafter until you've got policy approval in place, so it is really important to start thinking about that early. And there are only a finite number of drafters for the whole of Commonwealth legislative programs. So again, that links back to identifying what your policy priority is and how that fits in with the broader government context. Another factor that can have unexpected impacts on timing is just the composition of sitting weeks. Some are better than others for debate and getting things progressed. You should be aware of when only one house is sitting, budget estimates, budget week, all of those can have an effect. Also, the gaps between when sitting weeks occur can all have impacts upon the timing and progression of your bill. One or two issues that can affect timing that have probably been more relevant in recent years than previously is caretaker period and Parliament being prorogued. So caretaker is definitely a relevant consideration if you're looking to progress a legislative project at the moment. Caretaker occurs once an election is called and the House of Representatives is dissolved, and obviously once that occurs, no legislation is progressing. So if you have critical deadlines that you're working to, and they may fall somewhere around the possible timing for an election, that is a serious consideration to bring your time frame forward and work to get a shorter introduction. Proroguing is another process, I guess, which kind of cancels a parliamentary session. It's not very common, but it did occur back in 2016, and it has the effect of terminating all of the parliamentary business. So bills that have been introduced fall off the program. If Parliament is resumed, they can be reintroduced, but again, you have to start that process one more time. Some of these timing issues we, from a departmental perspective, can control, but some of them are just outside of our control and outside of our hands. So it's important to consider whether you have any timing constraints or critical deadlines as early as possible, so that you can produce a timetable with enough flexibility to deal with these unexpected delays and ensure your project is implemented in time. The second matter that I wanted to discuss today is managing ministerial expectations and competing parliamentary and government priorities. This is particularly a challenge towards the end of the legislative process just prior to introduction. There is a flurry of activity that needs to occur and a number of steps not only at the departmental level but also up in the Minister's office, in the Senate and the House Parliamentary Liaison Officers, and you need to factor in those competing tasks and processes to make sure you've got the time. From a practical perspective, one of my key tips is that if you are briefing the Minister, you're much likely to have the Minister respond in a timely fashion if he's received or he or she has received earlier policy briefings on the matter. There's nothing worse than submitting a brief seeking approval for legislation that's been drafted and having the response come back, what is this? So my advice to policy teams that I work with is always flag it with the minister beforehand, make sure they're across the policy issues so that when that brief comes up seeking legislative approval, often in very short time frames, they're not taken by surprise, they're ready to action it and it can be progressed quickly. It's also important to consider the competing challenges and timing considerations from the Minister's Office. Once we submit a bid and are at a departmental level ready for introduction, they still need to arrange for joint party and crossbench briefings. So they have other timing issues that they need to work into your timeframes. Having an appreciation or at the least a very general understanding of the behind-the-scenes work that the Minister's Office has to undertake can be extremely useful when assessing and managing departmental and other timeframes for introduction. My next tip is make friends with the DLO, and for that matter the PLOs and other parliamentary staff and PM&C legislation contacts. At some point in the legislation process, all of them will be extremely useful to you and you may need to call in favours. So pick up the phone, put a face to a name, become familiar with them, and it can ease what can be a very hectic and challenging time. So one of the benefits that we have with our offshore petroleum greenhouse gas storage amendment bills that we fairly frequently progress is that our minister and his office are becoming more comfortable with the process. But it's important to keep in mind that this is not always the case, and particularly when you've got new ministers, you should be prepared to explain to the DLO not only the departmental processes that we undertake to introduce legislation, but what their rights and responsibilities and duties are up at the Minister's Office to ensure it gets through. It can be extremely difficult to manage a legislative project in a sensitive political environment, and we are not always privy to the motivations behind ministerial priorities and urgencies. One thing that I found most challenging in my role as the LLO was needing to have frank discussions with the Minister's Office, the DLO, sometimes the advisors, about what could reasonably be delivered. One time confirming that, in fact, no, we could not draft and introduce a bill by next week. So this doesn't mean that projects can't progress efficiently, and if you've got an open relationship with your Minister's Office, it often helps. But from a departmental perspective, you do have to appreciate that sometimes there is genuine political urgency and things have to happen much faster than you would like. Generally, you'll get a much better outcome when you've got the Minister's Office, the policy team, the legislation team and other government agencies all appreciating the urgency and working collaboratively together. So one of the issues that I thought might be of interest today is addressing concerns from parliamentary committees. Most frequently you get the Scrutiny of Bills Committee or the Human Rights Committee bringing queries about legislative introductions. So it's important to know how to approach and respond to those. My first tip is to try and avoid having any comments from Scrutiny of Bills or Human Rights Committees. Being preemptive rather than responsive is always better, but unfortunately not always possible. My starting point is to, again, look at the legislation handbook. There is some guidance in there about what the Scrutiny of Bills Committees and the Human Rights Committees are looking for when they read explanatory memoranda that supports a bill that's been drafted. You can also look at accountability standards for the committees. These are generally contained in the standing orders, which can be accessed on the APH website. They give a good indication of what matters the committees are looking at and most interested in, and this does change from time to time. One of the key tasks in my role as the LLO was to assist the policy team by being able to review explanatory memorandum from the perspective or placing myself in the shoes of these committees. I'm trying to critically assess what within this bill is going to draw attention and how can we message it or explain it so that it will give satisfaction to the requirements of those committees. we didn't quite achieve this with the Petroleum Pools Bill, and we did receive a query in that matter from the Scrutiny of Bills Committee regarding retrospective commencement. The process that we had to undertake then was the committee raised their comments and concerns in an alert digest. We, as the department, liaised closely with the policy team and the legislation team to prepare a proposed response, which was briefed up to the Minister. The Minister then signed a letter with that response to be sent to the committee. We hoped that that would address their concerns and be the end of the matter, but in this instance, in a subsequent alert, the committee requested that an addendum to the explanatory memorandum be provided. So that addendum was drafted, printed and circulated all prior to debate, and as you can imagine, that caused quite an increase in work in a very short period of time. It is challenging to manage this additional workload at what is a sensitive stage of the legislative process, which is why I always say preemptive rather than responsive is better. But I guess it's important to be aware that the committees do take their roles very seriously. They scrutinise the bills and the explanatory memorandum closely, and they expect any queries that they have to be addressed in a timely manner, generally before debate will proceed. Covered most of that. So yes, moving on then to my final point, and that is that the department's role doesn't finish once a bill is introduced, although at that stage there is usually a big sigh of relief. Whilst it's true that at that point the timing issues are generally no longer within our control, our role doesn't end, and we still need to support the Minister's office through the debate stage. We do this in a number of ways. Most importantly is the preparation of a debate Q&A, question and answers. The legislation team works with the policy team to try and preempt any likely questions or issues that could be raised at debate, and prepare short answers that the Minister can use and respond to quickly. We also work to prepare a summing up speech. This is generally very similar to the second reading speech, but is often updated at the very last moments to include or amended to incorporate comments or address issues that might have been raised during the debate process. Our continued role becomes particularly important when there are proposed amendments during debate to a bill. So these can occur in a number of ways. There's government amendments. These are generally not considered unless they are critical in nature, and sometimes arise because circumstances have changed since a bill was first introduced. So if you've had a bill that might have languished for a little bit longer than expected in Parliament, and then during that time the situation has changed, you may need to move government amendments to address that. Another type of amendment is a second reading amendment. This generally relates to the broader principles or political considerations of a bill rather than the specific text itself, which is distinguished from amendments to the text of a bill that are raised during the consideration in detail stage. Often you'll receive notice of any proposed amendments in very short timeframes. You're required to work quickly. And it can also result in the need for, well, the last two can result in the need for government amendments to address these concerns, which can require some very quick redrafting, but I will leave that for Nick to talk on later. In the Petroleum Pools Bill, we were once again lucky enough to have not one but two different types of amendments proposed. We had a second reading amendment proposed by Senator Xenophon. This was an amendment to add text at the end of the second reading motion, which is when it's agreed that a bill be read a second time. It sought to bind the government to make further amendments to the OPGGS Act to improve competitive tension and to facilitate commercialisation and an increase in gas supply to the Australian market. So this was really a political manoeuvre to progress what was a policy concern of Senator Xenophon at that time, relating to the discussions, I guess, of a potential crisis in the domestic gas and energy markets. So Senator Xenophon was prompted to try and commit the government to a greater LNG production, which he hoped would increase supply and avoid this crisis that had been talked about. Notification of that proposed motion was received the day that the bill was scheduled for debate. So this required some extremely fast acting by the legislation team, the policy team and the Minister's Office in cohort to ensure that the motion was considered. The Minister's Office had sufficient detail on the context and the Minister's Office was able to make a decision which the Minister would then progress at the time of second reading speech, summing up speech, sorry. So that was the Minister's preferred response, was to incorporate the government's position into the summing up speech, and that's how we proceeded on this occasion. That same morning, we also received notification of an amendment to the actual text of the bill, so that was excellent as well. This one was proposed by Senator Hanson-Young and would have been addressed in the consideration in detail stage. Slightly different to Senator Xenophon's proposed amendments, Senator Hanson-Young sought to include text in the bill that would implement a ban on authorising mining activities related or in the Great Australian Bight marine area, which would drastically curtail the activities that were currently contemplated by the Offshore Petroleum and Greenhouse Gas Storage Act. Again, the process for managing this was similar to above. We worked in concert with the Minister's Office and the policy team to ensure that the Minister was appropriately briefed on the issues and was prepared to address the concerns during the consideration in detail stage, which is when amendments to the text of a bill are generally considered. So this has been a fairly fast-paced exploration into some of the key issues that can affect a legislative project. Specifically from the perspective of myself as an LLO. I hope you're able to take away a few pointers or matters for consideration, and of course I'm happy to answer any additional questions that you have at the end, but for now I'll hand over to Nick to give a drafter's perspective.
Thanks, Amanda, and thanks very much, Jess, for you've certainly helped me with my task, which is to give you a short and punchy summary of what the drafter does in the legislative process. What I'm going to talk about is I'm going to cover three areas or aspects of the role that the drafter plays in managing a legislative project. And the first is going to be working with the agency, with our instructors, to develop a draft legislation and put it through. The second is something that maybe it's more visible to us than to you often. It's the interface, the drafters or OPC's function to interface with whole of government issues and other agencies within government to make sure that the policy that's being implemented is consistent with whole of government policies and doesn't conflict with policies pursued by central government agencies and coordinating agencies. And I'm also going to touch a little bit on managing the bill in Parliament to add a bit to what Amanda has said. I'd like to emphasise really that the process should be regarded as collaborative. When I started in the public service, which is, as Peter has pointed out, aeons ago, we used to have a phrase when we were, someone would ring us up from another department or another agency or something and they want a favour, or we'd be offering to do them. We'd talk about the big family. It seems to have gone out of fashion these days. But to some extent, we're working together for a common goal. And that means in terms of working with the agency, it's a teamwork approach. So we'll have people from our instructors who may be from various areas of the department. We'll also have engagement with regulators or people from operational areas, from policy experts and legal oversight as appropriate, and expert legal advisors from time to time. And so it really, the drafter can help to bring all of those together, and it's in the table and to try to, we're really working together to implement that policy, sometimes to develop it in consult with where there are areas which still need development. So what happens first, OPC's first view, if you like, of legislation is as Amanda described, through the bidding process. And so really, we generally don't get to see much of legislation progress until a successful bid is made for parliamentary time. But in some cases, in some large projects or special interest projects, we'll be asked to sit in on meetings, planning the policy process for at an earlier stage. I did that recently with a project for a modern slavery bill that the government is preparing. And just so that they could get a steer on the sorts of issues which would be relevant to drafting the project. They'd done a lot of consultation, and I don't know whether it was useful, but it was certainly useful to them, but it was useful to us to get a taste in advance of what would be going on with the bill. But as I say, usually drafters, we can be we're certainly some of the detailed people, and it's sometimes difficult for us to contribute until there's a bit more solid policy groundwork based, and that'll be when there's a bid made, policy authority is being sought, and drafting instructions are issued. And this is just one small point about when drafting resources are allocated. Effectively, drafting resources are only allocated when drafting instructions come into our office. Policy authority may have been sought, may not have been sought. Drafting instructions are often issued, particularly for time-constrained projects. They're often issued in advance of policy authority, and we'll certainly need to be updated on policy and consult on getting that policy authority. And we'll look at previous policy authority, but until we get our drafting instructions and we can act on those from that point on the assumption that at some stage we'll get policy authority. Of course, as Jess has described, ideally there'll be a very good solid basis for the policy authority for our instructions going forward. If that ideal process is followed, that really is what sets the foundation for a good legislative project which will achieve the government's aims in a legally effective way, which is what we always try to do. Another thing that Amanda mentioned was the A for drafting category of priority, which is becoming rather common. And it's becoming more common, I think, because exposure drafts are becoming much more common. I think exposure drafts are great because they do help to put the project out to air and see what comes out from people who are interested in it from outside of government or for particular agencies in government. And so quite often A for drafting will be sought when you know that you're going to have to go out and and consult on this, but you don't think you don't need to get into Parliament in these sittings, but you need to have that exposure draft prepared in order to prepare for a future thing. That means that you can get some priority and you can get some drafting resources for that project to prepare that exposure draft. And just in terms of the drafting resources and timing, time passes a bit differently for drafters. We do get involved at a very concentrated part of a legislative project, but for all of you out there who are working on policy or giving legal advice for drafting projects, you're aware it starts much earlier than the drafting process actually starts. So we have an intensive involvement in the middle. If we have a really good policy foundation, if that policy is settled, we can actually work very quickly. But if that policy is not settled, it can be quite difficult. And if an effort is not put forward, as Jess has described, to really get tick all those policy boxes, all those maybe prior consultation boxes beforehand, if that doesn't happen, you find that you've got a partial policy, but you've got questions, you've got gaps, and quite often our experience as drafters is we come in with slightly fresh eyes and we can see some of these gaps and things which need to be still done, or else there hasn't been the time to do them. And so that will delay your drafting process. If you are not in a situation to give us to have a settled policy and to prepare and have prepared solid drafting instruction for those, you will not get necessarily a satisfactory draft within a good time, as you might have expected, because we don't have anything to go on. So this is what we also say. I just reinforce, if you like, double down on what Jess is saying about, if you can, to the extent that you can get your policy sorted out, that's the extent to which you'll get a successful legislative project. And the time it takes to get that policy sorted out is always well spent in advance of the drafting stage. Once drafting starts, it gets messy if you're still sorting out policy while we're drafting, we're going backwards and forwards. So time blows out, as I say. The other thing you have to be aware of, that except in the case of substantial or large projects, quite often your drafter is going to be working on other projects and they'll be at different phases of development, and so we're working in between. But as I say, if that policy is sorted out, you'll get our priority if you can answer our questions quickly, if you can sort out your policy quickly. That will give you better access to your drafter in terms of drafting resources. And another point with both of those acts, or the bills that have been talked about, the petroleum bills, I noticed that they're both, there were circulation drafts for both of them. One was a limited circulation draft and the other one was a public exposure draft. In terms of timing, just back on that question of time, for us as drafters, really preparing that exposure draft and the time constraint it puts on us is very similar to the time constraint of introducing that bill to Parliament. It's really, we have to put in just as much work to get that exposure draft ready as we would if that bill was going to be introduced into Parliament. So it has to be just as, if you like, the policy has to be settled. We have to tick off that there is policy authority for that, for the text of that, for what's given effect to in that text. So the policy authority has to be in order and the text has to be in order. Our quality assurance processes have to be in place, and the process I'm going to talk about in a minute about exposure to a whole of government issues, that has to be gone through as well before that draft can be authorised for circulation, for public circulation. So that essentially that means that an exposure draft is the product that you have to get ready for an exposure draft is more or less has to be of the same standard as the product for introduction. So you have to bear that in mind. You may be in a position to say, well, we're going to test the waters on this or that particular provision we've got in our exposure draft, and you'll go out and say, you might ask your stakeholders, this is the proposed approach, or would you prefer something else? That does give you the opportunity to reflect on that and to change the policy afterwards. But in terms of the product, the actual exposure draft that we present has to be of that standard. I'll make some comments, a few comments about, just better watch the time a bit here. Just a couple of comments about Jess's sources of policy authority. One of them is if the source of authority is, it's regulator issues in terms of the what can happen during the drafting process is if we get drafting instructions sourced from a regulator issue, they can say, oh, it doesn't really work. We want to do this and we can't do this, and the Act doesn't allow us to do this. That can quite often be, you dig down a bit more, and what you find sometimes is that what's been happening is not what should be happening. So the regulators have been doing something, they find they don't have authority to do that, and they'll say, oh, we just need to fix it up. And so, but then the drafter will say, hang on, what have they been doing? If you've been issuing these licenses or you've been refusing the licence for that reason and you don't have the authority to do it, that's going to get you into a bit of trouble, isn't it? And so you start thinking about that. That's an area where the drafter will help you with developing your policy, because we'll say, well, you might need to have some remedial provisions there, for example. We might need to do a bit of fix-ups here and there. And so you have to be aware, particularly if it's sourced by that sort of regulator anxiety, there are issues which quite often come out of that. Quite a few, where your instructions, as they quite often do, come out of reviews, such as, I don't know, the Montera inquiry or a departmental inquiry or a 3-yearly review that's built into a new piece of legislation, it's essential really for the drafter to have access to those reviews, even if they're internal reviews that you would consider confidential or whatever. We need to see those because we quite often, another pair of eyes, if you like, looking at that review, like the drafter looking at that review will see something, will pick something up that maybe from a policy perspective you'd missed in terms of the operation of the Act or something like that. So the more information the better at the instructing stage. Just a few comments about what happens when we work with the instructors in developing a draft. Very briefly, we like to have a face-to-face meeting with our instructors or a teleconference if people are interstate, particularly to start a project, but as the project moves forward it can be useful to iron out differences of opinion or misunderstandings. We will always, we're always very conscious of the parliamentary calendar and the sittings weeks because we have to count back from introduction week. We have to count back to getting the bill settled for introduction to LAP. We have to have editorial processes. We have to look at consultation. So timing is very much, it's a kind of a different calendar perhaps than what your overall policy framework is for this, but we can develop that in consult with you. It also helps, as I said at the beginning, for us to have a sense of who is responsible for, of some of the technical details from the operations area. It can be very useful to have conversations with regulators or with the operational area or with your legal experts if you've been getting legal advice to sort out issues. It's not necessarily just the drafter and the person who is in charge of the project as the instructing officer. We like to get involved with more people and so on, and we like to know who to go to. So that's in terms of our management of the project. It's really good to have lined up the important people in different areas who can answer questions. It's also really great if the instructor can be at a level where they can make some decisions, middle-level decisions about where the policy can go without having always to go back on the smallest thing to the policy area or to their supervisor to get authority. So for us, it's really useful to have an instructor who has the experience and also, if you like, the status or the brief to be able to answer those questions for us and to move the project along. So when we talk to someone, we really like to have a solid answer coming back to us, or at least to know that it's going to come back within a short period of time. On legal advice, which has been referred to, I think, by it may be useful to run out what OPC's position is in relation to legal advice. Of course, we're lawyers, but we are not authorised to provide formal legal advice in the way that AGS is on questions. Of course, providing draft legislation is in itself a form of legal advice. And we are always giving informal advice all the time. We're kind of notorious for giving legal advice all of the time to our instructors, if you like. But what we will do is we will also assess the need for getting legal advice from other parties or from experts initially and all during the process, as has been described previously. Very often it is only in the middle of a drafting process where it's, there's a constitutional issue coming up. You've said you want to do this. There might be an acquisition property issue here. You'll have to go and get some constitutional law advice. And we may also independently access the AGS database for advice on the legislation, so that even if you haven't got recent advice from AGS, we might go back to see, well, they must have got some advice when this provision was inserted, and so let's have a look at that. And that may prompt further investigations and the need for further advice. In terms of constitutional advice, we're in a position really to say that there are going to be significant hurdles for progress of that bill through to Parliament if we don't get constitutional advice. Effectively, we can put the brakes on it, so we can say you'll need to get constitutional advice because we think there is a significant constitutional issue. We may also highly recommend, although I don't think we can compel an agency to get international law advice from the Office of International Law at AGD, but if there's an issue with an international agreement, we think it's possible that we'd be in breach of an international agreement or instrument, then we will highly recommend that you do get that advice, and that's from the Office of International Law, even if certainly from your and in terms of the in-house legal advice, we respect in-house legal advisors, but in some cases, in terms of international law and constitutional law, we do require you to get that formal advice. And we'll certainly, if we think it's necessary to get legal advice about the operation of the law in other ways, then we may well ask for that. So again, that's something that I'm sure as government lawyers, you're well aware that we quite often do seek further legal advice on legislative projects as they go through. So that's more or less where we sit with legal advice. Constitutional law advice, we really are in a position to say we can't proceed unless you get constitutional law advice on the validity or the effect of this provision, and also possibly advice on how better, well, really, it's really about problem solving. How do we think there's a constitutional law problem, let's get a proper analysis of that problem. And similarly for international law advice. And that really leads me on to briefly talk about the whole of government area. Now, I'm sure anyone who's been involved in legislation has heard us talk about the referral process, and we refer our bill projects to a range of whole of government and other agencies. And you might be surprised if you look at, I really recommend actually when you're working on a project, have a look at our drafting directions, which are on our OPC website. Drafting directions 4.2 particularly is about referral of drafts to agencies, and there are about 60 matters there which have to be referred to the Attorney General's Department, various agencies there, and about 40 matters which have to be referred to other agencies outside of the Attorney General's Department. So it's a little bit scary. But these are matters where we see an issue in a draft, we say, oh, you'll probably have to send this off before the bill can be introduced to Parliament or before it can go out to exposure. We're going to have to send it out to get some comments or advice from these particular agencies. And just to give a short rundown, the other thing is we have a mechanism to refer that out to those agencies. We have contacts, up-to-date contacts within those agencies, and we have an automated system for sending out drafts with a memorandum saying where the issues are in the draft. But if you're in contact already with people from those agencies, or you would prefer to just have a one-to-one liaison with those, that's fine with us. If you are prepared to go to those agencies with the draft at a certain stage and get that advice, that's fine as long as we're kept in the loop. So in the Attorney General's area, anything that relates to courts, creation or abolition of courts, jurisdiction of courts, alternative dispute resolution, privative clauses, evidence, various other things. We'll go to the courts area of AGD. A very busy area of referral is in administrative law. If there's any new discretions granted or anything affecting administrative review, not anything affecting administrative review, but anything which is out of the ordinary or we think should probably be independently reviewable, but the instructing agency you've said that you'd really prefer not to, we'll send that off and they'll get some comments based on their policy requirements. Anything which we think anything relating to enforcement that isn't strictly, if you like, envisaged by the Regulatory Powers Act system. If you want to just trigger the Regulatory Powers Act system, we'll give you advice as to how to do that. And if there's nothing out of the ordinary there, it doesn't really have to be referred to, say, civil law, administrative law section in Attorney General's. But if there's anything additional powers which are given or anything unusual about that, that'll go there and they'll be able to help us to work that through. Criminal law issues, the Bible here really is a guide to framing offences. If there's anything which fundamentally breaches any of the principles in that guide, we'll want to refer it to criminal law area. Similarly, if there's any coercive powers, unusual coercive powers. Information law goes to areas of Attorney Generals. Office of International Law is also a very common referral, and we'll go to them for initial advice, if you like, on a series of issues, and they will generally flag if they think they need to prepare a more formal advice on international law. But so that essentially we say that there's an international agreement here, or there's some international law issues here, can you give us some advice on that? Or citizenship, refugees, human rights, external affairs power, those sorts of things. And they will come back and say, we need to give this a bit more attention, or you might like to make an arrangement with AGS, who can provide international law on our behalf, international law advice on our behalf. And so and there are some selected areas of constitutional law which relate to government, whole of government constitutional law policy, and that's particularly in the area of referral. If your project requires referrals from the states for constitutional power, you'll need to consult, if you haven't already, of course, constitutional law area of Attorney Generals. Anything that might affect relations between the Commonwealth and the states also has to go there. And I imagine that the projects that Jess and Amanda talked about would have had to at least be put past constitutional law area in AGs, because it involved a relationship with the Western Australian Government and the Commonwealth Government. So those are some the main areas, if you like, of interaction with Attorney Generals. Other agencies, the Public Service Commission, anything to do with statutory officers or public service legislation or staffing. Finance we have to refer bills to finance if they create a standing appropriation, or if they create special accounts or statutory bodies, or anything to do with the PGPA Act, broadly speaking. There are some funny referrals, the unusual ones. We have to refer anything to the ABS, which cites an ABS publication. So most indexation provisions have to go to ABS. Geoscience Australia actually is one of the agencies we have to refer to if we put a narrative description of location in legislation, or I imagine if we want to put maps and things like that in. Another area of consultation, there's a number of other agencies there. Auditor General, external territories, environment or infrastructure have to be consulted on those. PM&C is consulted on the status of agencies, Indigenous affairs and government appointments, Commonwealth appointments. Treasury has to be consulted on corporations law matters, the Ombudsman and various. Essentially, that's our role really, is to pick those issues up as they come along. We don't expect you to know those issues, but if we pick those up, we'll say, look, we can refer the bill once it's settled. Do you want to go and talk to them? If, for example, it creates, like the bill that we did in response to the Montara inquiry about compliance powers, involved a huge a shift in the way that the compliance regime under the Act was working, and we had to go. It really was useful for the policy area to work closely with AGs directly to work that up. So it wasn't just a matter of, here's a copy of the bill, give us your comments in 2 days' time. It was really just, we need to work this through and properly develop a policy which will work. That referral, unfortunately, can take place very late in the process, and we put a lot of pressure on those referral agencies. But if we've got a settled draft and we know it's going to have to go out, the sooner we can get those comments back, the better, because sometimes we can be taken by surprise. It's very nasty to be blindsided at the last minute. For instance, to come back, get something back from oil saying, there's a significant risk here that we're going to be breaching such and such an agreement or convention that hadn't been anticipated. Sorry? Yeah, I think what I might do is, I was going to make a few comments there about managing the bill in Parliament, and I'll just conclude by saying what Amanda said, reinforcing what she said, is the best way to deal with the bill in Parliament is to make sure that we anticipate all of those responses from the committees in advance, and that we deal with it in the draft or in the explanatory memorandum. So that's another thing that we're very good at, if you like. One of our specialities is that sort of anticipatory response. Build it into the bill is much better than having to explain yourself when you get those letters from the committees. But I hope that we can now take some questions from the floor. I'm afraid we've run very late, but if people are happy to stick around, we're happy to stick around to answer a few questions. Thank you very much.
Well, thanks very much for that. And so you've got just a couple of minutes for questions. So we've got microphones, so if you've got a question, if you just wait till the microphone gets to you and then identify yourself. So would someone like to be the first one to start with a question? You're all exhausted.
My apologies for the temperature in here. I know some people like me are freezing.
Hey, you want to keep it nice and cool so you know you're in Canberra. Any questions? If there's not, we might move to thank our speakers. I think it's a very interesting topic, and certainly being covered from three perspectives, which I think cover the field of it. So I ask you to join me in thanking our three speakers for today, Jessica, Amanda and Nick. And as you would have seen on the screen, the next one's on Thursday the 28th of June, which all of us here no doubt know that's the last sitting day of Parliament, so that could be a fun day. But that'll be here again and looking at different models for delivering legislative services and how that can affect the development of legislation. So thanks everybody for coming and for your attendance today, and look forward to seeing as many people as possible at the June seminar. Thank you.